It's 10:01, so I think we should get started with our program. I'd like to welcome you all to the Financing Section Explained. I am as excited about this program as all of you. We receive, first of all, my name is Joanna Watkins, for those of you who may not know me. I have the honor of serving as Florida Realtors General Counsel. And it is indeed an honor. I say that every time I have an opportunity to speak to our membership, and I mean it as sincerely today as every time I say it. I have the pleasure and the honor of leading a team of 15 attorneys on behalf of Florida Realtors. And one of the product, services, and tools that we are most proud of at Florida Realtors is our FAR contract that we produce in coordination with the Florida Bar. As attorneys, we get so excited about case law and things like that. And I can tell you that I have read opinions where courts in this state have labeled this contract fair and balanced and consumer friendly. And so we are thrilled that for the last 3 years, a group of realtors and attorneys have worked very hard to put together changes that we feel are reflective of a modern real estate industry. And we are going to roll out these changes. And of course, how do you change a contract without addressing the financing section? And so today we are going to present a program to you solely about the changes to the financing section, because it is in and of itself enough to put on its own program. So I want to, before we get started with the changes, take a moment and tell you that we could not do what we do without the support of an amazing leadership team headed by our very own President, Cheryl Lambert. She is on today along with some of our outstanding leaders at Florida Realtors. And so I am going to turn it over to President Lambert to talk to you for a moment about this webinar, and the work of our amazing leadership team. President Lambert, the floor is yours.
Can you hear me now?
Yes, ma'am.
I am seriously going to get a t-shirt that says unmute. I just have to unmute. So, well, good morning, everyone. And thank you so much. Right now, we just hit 900 people actually on this call out of the 1,400 that have registered. We are blowing. I am so proud of this membership and this association and our staff, because they list, they truly, the legal department, as much as everyone says, I got to call legal hotline. But at the end of the day, the legal department truly listens because they brought these issues forward. And this is something that I can say in my area has always been a bone of contention, is the finance part of the contract. So to have it looked at, fixed, and addressed is awesome. And everybody's excited about it. So, but we would not have that awesomeness if we didn't have such a great staff at headquarters. They blow us away every day. And so for us to give you support, Joanna, is very easy on the leadership part, because you guys are just awesome. We have the best in the country, and I keep saying that. We have the best of everything in the country. We have the best members. We have the largest members. We're the largest, which I love being number one. And Florida is number one in many things. And this is our second webinar on this contracts with Marsha and Joanna, and they knocked it out of the park, the first one. And they also broke records with the number of attendees that participated. So talk about being innovative. Those are the three things I asked everyone to do this year, was to inspire, encourage each other, and that's what they're doing, and be innovative. And talk about innovative. When you are having 2,000 and 3,000 registered for a Zoom call, think about that, for a Zoom call. You're just breaking down the barriers. And we set the tone for everyone else in the Texas, I got a phone call from the president of Texas, and he said, Cheryl, he goes, you make it very hard for us because everybody goes, well, if Florida can do it, why can't we do it? And we're just as big as Florida. I says, no, you're not just as big as Florida. Let me correct that now. We're the largest. So anyway, again, we have to be number one. And honestly, I couldn't lead this organization the way I have without my tremendous support of my great leadership team. And so I'm going to introduce a couple of them that I can see on. And if I miss somebody, please. And I can tell you, Christina and I talked yesterday, our president-elect, and she is preparing for her year. And I'm so excited for her and her team. And so she's unable to make today's call. So she says hi to everyone. So I just wanted to pass that along. But she truly has been my right hand, and she's been phenomenal. And then there's our treasurer, Gia Arvin, and our secretary, Tim Weishire. And our newest member for the 2022 team, let me stress 2022 team, is Chuck Bonfiglio. So congratulations, Chuck. You'll have a great year with Christina. You guys are going to be awesome. So I'm looking forward to watch this team continue to lead. So with that, Gia, would you like to say anything?
Just thank you guys for taking time to really learn the new contract and the changes. We're happy to have you, and let's get going.
Thank you, Gia. Tim, would you like to say anything?
No, thank you, Madam President. Everything you said was perfect, and I couldn't agree more. So welcome and good morning to everyone.
Great, thank you. Okay, the newest member of the leadership team, Chuck, would you like to say anything?
You pretty much covered it all, but between MLS and contracts, those are the two most important things in our business. So again, hats off to our staff and our great state for trying to make our life easier so we can write some more business. So thank you.
I think that covers the whole team. I didn't see if Mike was on. No? Okay. Joanna, I'm going to hand it back to you, our general counsel.
Thank you so much, Madam President and members of the leadership team. I will say Margie Grant could not be with us this morning. She tried her hardest, but she couldn't make it because she had a conflict. So without further ado, I'm going to introduce two members of our leadership team. Carol McKee is one of, I believe actually Carol is the longest serving attorney who serves on our hotline team that we have here at Florida Realtor. She's been around forever. She has a wealth of knowledge, and she is going to be monitoring the chat today, giving you vital real-time information with your questions. So please keep those questions coming. I will also be on the chat to help answer those questions. And without any further ado, I bring you Marcia Tabak. Marcia joined Florida Realtors Law and Policy section in, I believe, 1987, Marcia. She is our Deputy General Counsel, second to none in her knowledge of this contract. And you will see why in just a moment. So, Marcia, I turn it over to you.
Okay, great. Good morning, everybody. Okay, there we go. Another fireside chat with Marcia today. You all are very welcome to this webinar. So this is the second webinar in a series of 3 that we are going to be sharing with you regarding the changes to the 2021 Florida Realtor Florida Bar as-is contract. Okay, so today I'm hoping that you all have next to you a copy of the as-is draft form, which does not contain the markup, so no red lines. I'm hoping you have that because the slides on my PowerPoint coordinate with the line numbers on the as-is, okay? If you don't have that document, you can paste this URL into your browser. It will take you to a page on Florida Realtor's website. You simply need to add your username and password, and you will then find the page with all of the tools that we have developed for you to use when familiarizing yourself with the changes. So, as Joanna noted, what we're doing today is we are going to focus solely on paragraph 8B as it will appear November 1st. So for the next 2 weeks, you are going to continue using the Florida Realtor, Florida Bar, as is 5. But November 1st, we're going to replace that document with the new document, the as is -6, okay? So another couple of pointers. My PowerPoint slides are not exact. The red letters do reflect new language, but I didn't include all of the deletions because the slides became too cluttered, okay? My plan is to walk you through each and every concept that is involved in paragraph 8B, and I'm going to focus on the new. And lastly, I want to reiterate to you all, first of all, I'm really sorry that we can't have a dialogue. I mean, I know we learn best when we're interchanging your ideas with our information, but with so many people on the webinar, that just isn't possible. So again, as Joanna said, please submit your questions in the chat. Carol and Joanna are going to do their best to keep up with your questions, but you know, honestly, that with so many of you, it's probably not going to be possible. But don't worry, because the third webinar that we're going to do sometime down the line is we just want to share with you the common questions that we are going to be receiving on the contract and that we have received. And we'll share with you answers and guidance. Okay, so that's what we're planning as the third webinar. So today, why are we focusing on paragraph 8B? Well, when Margie asked us to do this seminar, I reached out to one of our forms vendors and I said, could you tell me out of the number of documents that have run through your system, offers and counteroffers from January to the end of September, how many times was 8B checked off? So roughly out of 500 forms that went through this forms vendor, about 60% of those forms included 8B being checked off. Okay, so we know this paragraph is touched a lot by you guys. It contains lots of details. It contains blanks. It contains checkboxes. It's critical because it's the roadmap for funding the purchase, which is the subject of the contract. It generates by far the most questions on the contract we get on the legal hotline. In addition, whether you're representing the buyer or the seller, it creates rights for both parties. So it's important for you to understand. And lastly, this particular revision involves a significant philosophical shift in direction. Okay, so I want to talk with you about that a little bit. The directional change that 8B has taken was the result of a lot of debate. And the debate takes place in meetings of the statewide Realtor Attorney Committee and the subcommittee. It is this group that reviews and drafts the revisions to the contracts. They spend a ton of time on paragraph 8B, and they really focused on this provision. And the result was they purposely changed some of the requirements from the current version. The best way that I can think of to explain this directional shift is for you to think about how the current 8B works now and for you to consider the current lending landscape. So when a buyer checks off paragraph 8B, the buyer is making their offer to purchase contingent on the buyer obtaining financing. This, of course, requires the buyer to find a lending source. The lender, once located, typically conducts a two-pronged vetting process. First, the lender vets the buyer in order to ensure the buyer can repay the loan. How is the buyer vetted? Information is sought, documentation is sought to verify the buyer's ability to pay. But in addition to the buyer being vetted, very often the lender also vets the property being purchased with the loan proceeds. This is done to determine that the debt is sufficiently secured. Now, how is that accomplished? The property is typically appraised with regarding its condition and its value. So with that having been said, you will realize that the current contract deadline for lenders to vet a buyer is loan approval period, while the deadline for lenders to vet the property extends all the way to closing. So what the committee did in this 2020 revision is to make that vetting process the same when the lender vets the buyer and when the lender vets the property, so that both will be concluded and accomplished within loan approval period. Okay, so that's sort of the directional shift I wanted you to understand, and now I'm going to show you how that played out. Starting with paragraph 8B, we're going to start with lines 89 through 90 and then piggyback on lines 90 through 94. Now I've got the simplified language on the screen, and you will see some red lettering, but no real substantive change has occurred with this part of the contract, okay? The buyer's offer is contingent upon accomplishing certain tasks within loan approval period. That is the same. The parameters for establishing loan approval period are also the same. So when you look at the top of the screen, you'll see the contract is contingent upon, and then you've got a blank. And what you do is you insert the number of days you want to apply for loan approval period. And if you don't complete that blank, I'm sorry, I'm getting a phone call. If you don't complete that blank, then the default remains the same. It's still 30 days. Now, moving forward to line 90 through 94, you're going to recognize what's in front of you on the screen again, because what you're going to see is a description of the loan the buyer is to seek. So the buyer is to obtain a loan that is consistent with the description in the contract. The contract still requires that the buyer describe what type of loan the buyer wants, whether it's conventional, VA, FHA, whether the loan will be fixed, adjustable, or either. In addition, the contract allows you to put an initial interest rate cap in the blank, as well as complete the term of the loan the buyer is seeking. So all very familiar to you. But when we get to lines 94 through 96, which show up on your screen in red after the number 2, what you'll see is new language. And what has been added is a new task to be completed within loan approval period. And what that new task is lender is to receive a satisfactory appraisal, that being an appraisal or an alternative valuation sufficient to support the loan if the lender requires an appraisal. So for the first time, this contract is requiring the appraisal to be delivered to the lender and satisfactory to the lender within loan approval period. I wanted you to notice on paragraph 8B, lines 94 through 96, that the word appraisal has been expanded, and it covers more than an appraisal because it includes alternative valuations. And I've got the language on the screen which describes this. Why did the authors do this? Well, the drafters of the revisions recognize the fact that some lenders are no longer requiring full-blown appraisals. Some lenders on some loans accept a different type of valuation product. It could be an evaluation. It could be a desktop appraisal which involves no on-site inspection, or it could be an appraiser-assisted AVM. Okay, so once I've explained that, the question we have received from you all often has been, does this now eliminate the need for us to use an appraisal writer? So I have to sort of ask you a question right back. Why are you using the appraisal writer? Remember, what this does is provide a satisfactory valuation to the lender. And if that is the purpose of using the appraisal writer, it is built into the contract. But if the purpose is for the buyer to be satisfied that the property appraises, and that is uses a full appraisal to meet the value that the buyer has assigned to it, then it doesn't eliminate the need. So in other words, if you have a buyer that wants to ensure that the property has a full-blown appraisal and that the property appraises at a specific amount, not what the lender is looking for, but what the buyer is looking for, then it doesn't eliminate the need. But if the buyer is unconcerned about what the property appraises at, and the only real reason value comes into play is to ensure that the lender will make the loan, then the language is sufficient. Okay, so in conclusion, with regard to this paragraph, lines 89 through 94, what we have is the contract being made contingent upon the buyer obtaining approval of the loan described, as usual, as well as the lender receiving a satisfactory appraisal or valuation, whatever it is the lender is looking for, if the lender requires one, all within loan approval period. So that is in total what this paragraph is about. Now, you all have asked how many days should be filled in for the loan approval period. And my answer to you, those of you that represent buyers, most of you all pre-qualify the buyers, and the buyer knows what lender they're going to be using. So my tip to you is to find out from the lender the buyer plans to use how long they need not only to approve the financing of the buyer, but also to receive a satisfactory appraisal. And that would be the number if it's different than the 30-day default period to insert in that blank. This moves us forward to paragraph 8BI. And so now we're on lines 97 through 99. And this language is going to be familiar to you. This is the paragraph where you designate when the buyer needs to apply for financing. And if you don't complete the blank, the default is 5 days, and that remains unchanged. This is also the paragraph that specifies for the first time the buyer has to use good faith and diligent effort to obtain the loan and to get loan approval. Now, what's new about this is that loan approval equals the buyer's financing being approved, which is as it was before, but also includes the lender having received a satisfactory appraisal or evaluation if required. So that part is new. And again, ties into my remarks at the beginning where the committee was attempting to include the satisfactory appraisal in loan approval within loan approval period. The other part of this provision that I want to call your attention to is on line 99 through lines 101. And this has to do with loan approval, which requires a buyer to sell a property. Previously, that was not considered loan approval under the old contract, the current contract, but it will be considered loan approval if Rider V entitled Sale of Buyer's Property is attached to the offer. Now, why is that? Because if a buyer checks off 8B and indicates that he is going to obtain financing to buy this property and also uses Rider V, which informs the seller the buyer has to sell a property to get the financing, then a loan approval that specifies this will be considered loan approval. The buyer who doesn't reveal the need to sell a property and doesn't use Rider V should not be saying they got loan approval if it is conditioned upon them selling a property. So with that in mind, I just kind of want to do a little spot check with you all. If an appraisal is conditioned upon, I can't see my screen. One second. If an appraisal is conditioned upon the property needing to appraise, is this loan approval? So the answer to that should be no, because we said loan approval equals the buyer being approved, for the loan and the lender having received a satisfactory appraisal. If the approval is conditioned upon the buyer selling a property, is this loan approval? The answer to that is it depends. As long as Rider V has been used and the seller has been informed the buyer has to sell a property, then yes, that's loan approval. If Rider V is not used, then that is not considered loan approval. What if the approval contains other conditions? Well, there was nothing that I said so far that required the loan approval to be unconditional. Okay, so for our purposes at the moment, a conditional loan approval constitutes loan approval, assuming it doesn't include that the property still has to appraise and assuming that it doesn't require the buyer to sell a property if Rider V was not attached. So what if the appraisal is received by the lender, but is insufficient to meet terms required for lender to finance the purchase? Is this loan approval? And I can't see anybody, but I am hoping that you all are saying this is not loan approval because as you can see on the screen, loan approval is the buyer having received approval for the loan, making the financing available, and also the lender's receipt of a satisfactory appraisal. So we're kind of shifting mindsets based upon this shift in direction, but it's pretty clear, I hope, after you've had a chance to digest this, that loan approval is as it was before, with the exception of the appraisal has to be completed within loan approval period. And if the loan approval requires the buyer to sell a piece of property, then that is loan approval only if Rider V has been used. One of you all asked, is there required language for a loan approval? And so I've got that on the screen just to talk about it briefly. There is no magic language that really constitutes a loan approval. What I would be looking for is a commitment on the part of the lender saying, we will loan this amount of money under these terms that match the description of the loan you put in the contract. And I would also look for the fact that the lender is loaning on a specific piece of property, which you've described in the contract, which is the subject of the sale. So moving to the next part of 8BI, lines 102 through 105, this language on the screen should be familiar to you. Conceptually, nothing significantly has changed here. The buyer still needs to use good faith and due diligence when seeking the loan approval, and that includes they've got to apply for the loan, furnish all info to the lender, and pay appraisals and other fees. The one question that we have fielded on this one, sort of stems from, a practice that those representing buyers really try not to have the buyer expend money on a transaction, and that is paying for the appraisal, until they're through the inspection period. So the question is, can buyer wait to pay appraisal fees until inspection period passes? I just want to remind you that the contract requires good faith and diligent effort. It requires the buyer to pay for the appraisal and other fees and charges. So remember, the lender will not order the appraisal until it's been paid for, or the product, that if it's not an appraisal. So because the appraisal needs to be completed within loan approval period, you're going to want the buyer to pay those fees as soon as possible so that the order will be placed and the appraisal be completed early in the process. Now, this may mean that you have to, immediately set up an inspection of the property, and that's fine. You just keep that in mind, because everything is sort of expedited now because the appraisal needs to be completed and satisfactory to the lender within loan approval period. Okay, this moves us forward to paragraph 8BII, lines 106 through 108. And this paragraph too will look familiar to you. This is the paragraph that specifies the buyer is to keep the seller and brokers fully informed about the status of the buyer's mortgage loan application, loan processing, appraisal, loan approval, and the factors relating to the loan. Okay, what's different is now the buyer's obligation to do this is triggered upon the buyer receiving a written request for this information. So that's new. And the other thing that's new is that the buyer, if they do receive a written request to keep the seller and brokers informed about these details, the additional item that's been added here is that the buyer is to keep the seller informed about property-related conditions of the loan approval, okay? The question you all have been asking is, what are property-related conditions? So the committee, when they were putting this together, thought about an inclusive list of property-related conditions. But as soon as they contemplated this, they realized that they would not be able to come up with an exhaustive list, because no doubt there would be an additional property-related condition that hadn't been contemplated and wasn't in the list. So they decided not to specify what property-related conditions are. So the way I look at it is similar to the way I talked with you about the way a lender vets a buyer and the property when entertaining lending funds. Some of the conditions of the loan are very clearly related only to the buyer, like you got to give us 3 years of your tax returns. We need your pay stubs, Mr. Buyer. Those kinds of things are clearly buyer related and not property related. Other matters that involve the property itself, the value and condition of the property, arguably are property related conditions. So what I want to do is leave you with that thought to where we can talk about this more in detail at our next seminar when we talk about questions and answers. But that's what I want you to think about with regard to property-related conditions at the moment. The second part of 8BII on lines 108 through 110 involved the buyer giving their lender, a mortgage broker, permission to talk to you all about status and progress of the details of the preliminary and finally executed closing disclosure. So the question we get from you sometimes is that you have reached out to a lender or a mortgage broker and they won't tell you the information you're seeking. And, I can tell you that we have this authority provided for in the contract, but we can't make the lender change their policies. So we can lead the horse to water, but we can't make them drink. Continue to try to get that information from the buyer himself, and do that by sending the written request and staying on top of it if you're not getting that information. Okay, this moves us on to paragraph 8B III, lines 111 through 114. So this is the provision that deals with the buyer who does obtain a loan. And as before, the buyer is supposed to notify the seller in writing within loan approval period that he obtained the loan. So what's new about this is the timing is slightly different. Under this version of the contract, the buyer has all the way through loan approval period to make that notification, whereas the old contract or the current contract required the buyer to notify the seller promptly. But there is some new language in this subparagraph, so I want to talk about that for a minute. So in paragraph 8B III, lines 112 through 114, you will see new language. And the language, and I got it on the screen, says that the buyer is unable to obtain loan approval, but is satisfied with buyer's ability to obtain loan approval and proceed to closing. Buyer can deliver a written notice of this. So what this new language does is actually allow the buyer to continue to proceed pursuant to paragraph 8B with closing on the contract, even though they didn't get the loan, because they're saying, we are sure we're going to get it and we want to close. So that is new. The question that we received on this one from you all was, does the buyer have to provide the seller with proof that he actually can do this? And I've got to say, there's nothing in the contract that requires that. But the buyer who does notify the seller in writing that he's confident of obtaining the loan approval and proceeding with the closing is at risk, because if the loan approval is never obtained and he needs it to close, then he's going to lose his deposit, okay? That moves us forward to paragraph 8B, little IV, which is 8B4. And this deals with initially when the buyer does not obtain loan approval. And it is as before that the buyer who doesn't obtain loan approval within loan approval period can terminate the contract by sending written notice to the seller. So that's as it was. The question that you all sometimes ask us is, what if the buyer is not approved but has no denial letter? Well, you can see the contract doesn't require a denial letter. It requires simply that the buyer can terminate if they were not approved, not that they have to be in possession of a denial letter. But I want to focus a little bit on lines 115 through 119 in paragraph 8B IV, which is paren 4, because we've got some new language. And it goes on to say, if a buyer actually does obtain loan approval, but cannot timely meet the terms of the loan approval after the exercise of good faith and diligent effort, he too may terminate the contract. So this sub 4 paragraph allows a buyer who never gets the loan approval to terminate, and it allows the buyer who does get a loan approval but can't meet the terms of the loan approval timely and in good faith to terminate the contract as well. And that language is new. The latter language is new to the contract, but the concept's not really new, because it really would be unfair to require the buyer to forfeit their deposit if they're in possession of a loan approval they cannot meet the terms of timely and in good faith. Okay, now we're on paragraph 8B5, and this deals with the buyer who does not reach out to the seller in writing and does not tell the seller that he got loan approval or that he didn't get loan approval. Essentially, he remains silent. So as before, the seller has a right to terminate that contract within 3 days after the expiration if that buyer has remained silent. But the consequence of the buyer remaining silent has changed in this version of the contract from the current version. So in this version of the contract, the buyer who remains silent and does not get terminated by the seller within those 3 days needs to proceed to close, but he needs to proceed to close as if it's a cash transaction. Okay, so if he doesn't close, he's going to lose his deposit. That brings us to paragraph 8B, little vi or little 6, lines 126 through 131. So this has sort of had some massaging and changes as well. So I want to talk about this as well. Under the provision now, I'm sorry, I wasn't expecting any phone calls today. So under this provision, the buyer who notified the seller he got loan approval, or that he didn't get loan approval but was comfortable that he would get loan approval and is proceeding to close, that buyer, if he fails to close, will lose his deposit unless one of two things occurs. And if the one or two things are going to be familiar to you, that buyer will lose his deposit if the closing doesn't occur. He'll get his deposit back if the closing doesn't occur due to the seller's default or the inability to meet the property-related conditions of the loan. What's different about this is that the buyer will not get their deposit back if the if the appraisal is insufficient to meet the terms of the loan. And why is that? Because all of that occurred within loan approval period. The lender will have already received the appraisal. So this issue will not come up at closing. And again, this is what the committee was trying to solve by requiring the lender to receive the satisfactory appraisal as part of loan approval and within loan approval period. And in that vein, under item 2, the property-related conditions, the committee has added that an appraisal valuation will specifically be excluded from a property-related condition. Okay, so we have traveled through the financing clause, and I want to just recap it now, and I hope it's going to make some sense to you. When a buyer checks off paragraph 8B, he's making his offer contingent upon the buyer obtaining the financing that's described in the contract and the lender receiving a satisfactory appraisal or valuation if the lender requires one, all within loan approval period. The buyer still has the obligation to apply for the loan on time, to use good faith and diligent effort to obtain the loan approval, which will include obtaining an approval for the financing, which, as we've said, could be conditional as long as it's not conditioned on the buyer selling a property unless Rider B is attached, and a satisfactory appraisal is received by the lender. The buyer still has to keep the seller informed of status of loan application, processing, appraisal, loan approval, now including property-related conditions, if the seller provides a written request for this. The buyer then needs to notify the seller in writing that he got loan approval or he intends to proceed without it. Or if the buyer doesn't get loan approval or does get it but can't meet in good faith the terms of the loan approval, the buyer can terminate. Where the buyer stays silent as to whether he got loan approval or not, assume box 8A has been checked, which makes this a cash contract not contingent on financing unless the seller terminates. And then lastly, assume buyer who sent notice that the loan approval was obtained or that he would proceed to close without it will lose his deposit if the transaction doesn't close, unless the failure to close is due to the seller's default or property-related conditions were not met, if not waived by other provisions. So this is sort of it in a nutshell. There's a lot of moving parts, but if you take a moment, read the contract, possibly look through these slides again and listen to the PowerPoint, it's going to make, I hope, sense to you. And we've still got 2 weeks before we're replacing this form to give you plenty of time to think about it. And please, if you would, continue to send us your questions. You can call the hotline with them. You can submit them now. And we really appreciate your participation. And with that, I'm going to just turn it right back over to you, Joanna.
So thank you all so much. The chat has been on fire, and I want to thank you for that. So listen, what you probably heard Marcia say a lot during this meeting was the fact that many of these changes came from calls into the hotline and comments from all of you. This is your contract, and these are your changes. And it's so interesting. I was looking in the chat, and, one person said, wow, this is so buyer friendly. And another person said, you have really backed the seller into a corner here. And I'm not surprised by that because, a lot of times members feel strongly one way or the other about this. But I started off earlier by saying that courts have routinely viewed this contract as fair and balanced. So, I'm thankful that we do have what I think is a good consumer-friendly, balanced contract. That is always our goal because we have members on both sides of this transaction. And we are thankful that Marcia has given us an hour's worth of really good insight into what the rationale was behind these changes. So thank you, Marcia, for that. Thank you, Carol and Meredith, for jumping in to help us with the chat because it was truly on fire. I want to thank Margie and the leadership team for being so supportive of this 3-year process that has brought us to this point. Thank you all for taking time out of your busy schedules. Just a reminder, this video recording and the slides will be available on the Florida Realtors webpage for your use, your download, your training, your personal development needs next week. So stay tuned. Feel free to go out there and grab that information next week. Use it. Get it to your agent so that they understand the changes to this contract. Next up, a couple of resources that will be available to you. Also going up next week is something called a talking contract. This is a great resource that we've developed with our communications team. You can literally go to the contract that we have posted, click on a section that we changed, and there will be a narrative explanation read to you to explain the changes. Okay, we want to give you all as many resources as we can in various formats. We want to meet you where you are, whatever works for you and your learning style. And so that will also be available next week. Use it. Also coming up is another webinar video with frequently asked questions. All of these questions from the chat, all of the questions from the last chat room will be used to develop a frequently asked question resource for you that will answer your questions in detail. We are not practitioners. We are lawyers. You are the experts in the field. And so we appreciate your questions because you have a unique perspective we do not have. So we will get those questions out to you shortly after probably the implementation of the contract as we gather those questions with the rollout. But there will be some that we release prior to that deal with things like I got a contract on October 28th, but we want to make an amendment to the contract on November 2nd. Is it okay to use the new form? So we will have some that come out before the implementation of the contract and some that will come out after. So stay tuned. Thank you for all that you do. Thank you for your patience. Thank you for your participation. Have a fantastic week. Bye, y'all.